and he's yielded. And the gentleman from California, Mr. Liccardo, is now recognized for 5 minutes.
Thank you, Mr. Chair. Thank you to our witnesses for all this information. The hearing, of course, is captioned "Follow the Money," and I used to be involved in prosecuting drug traffickers and human trafficking as a federal prosecutor and later as a DA. And certainly I had plenty of challenges following the money when we knew there was information being provided by entities that was false, that would conceal who the actors were and who was controlling them, and most importantly, who was getting the money from the criminal enterprise, because we knew those were the folks who were really running the show. I'll give you a quick example. I remember a Cuban national who was controlling a major human trafficking enterprise in Southern California, of course, using entirely U.S. corporations filed under California and other states' laws with U.S. citizens, essentially, ostensibly being their officers. So I'm concerned, as I know the National District Attorneys Association is also concerned, based on what we see from their statement in December of 2024, at this legislation that we're currently considering that would exempt every U.S. corporation under a certain threshold size from Corporate Transparency Act's requirements providing basic basic ownership information to FinCEN. And let's be clear about what that information is under the law. It's the name of the owner, their date of birth, their address, and some identifying number from a driver's license or passport or some other government. That's it, 4 items. Now, in my experience, certainly trying to get the identity of those individuals controlling these entities that are engaged in criminal activity was pretty important. And I guess I just wanted to ask Stokes, does it help, based on your experience, to be able to have this kind of information if we're trying to combat fraud?
Thank you, Representative. Absolutely, the information is critical. And I just want to point out that we've heard a lot about concerns of administrative burden and concerns of data privacy. I want to turn to the burden of the victim. When you look in the aggregate of how much has been stolen just in 2023, an estimate from the FTC, $158.3 billion. That is 3 times the revenue of the Coca-Cola Company. We have to understand that, yes, there are burdens on businesses, and maybe some could be put together better than others, but we can't be moving away from rules that help protect consumers.
I agree, Ms. Stokes. And in fact, I believe Mr. Brabant suggested somehow or another corporations have to hire CPAs and outside counsel to be able to submit this information about the name of the owner, the date of birth, address, and their basic, driver's license number. Is that your experience, that you need outside counsel to do such things?
Thank you, Representative. I can't speak to that because that's not the space I work in, but I hear your point.
Yeah, so $153 billion in loss.
$158 billion.
$158 billion. Thank you for that. Mr. Brabant, you might have guessed I was going to you next. I'm trying to understand why providing these 4 basic pieces of information, which, by the way, I had to provide when I opened an LLC last year. Any bank would require it. It's pretty basic information. What is the extraordinary burden involved here?
It's also a photocopy of a driver's license, but it's that information. The challenge is the substantial control prong. And I think one thing that's getting lost here is that every bank already has this. So this is a duplication of the customer due diligence rule, which already exists. So every single LLC that has a bank, if the bank is doing its job, they have this information. What this is really
what happens
if
the bank has individuals who are involved in the criminal activity? Wouldn't you want that information in the hands of those who are investigating criminal activity, not those who may be complicit?
Anyone who's investigating could subpoena the bank for it at any time.
And what happens if you're just investigating for the first time and you actually need to know who you can subpoena? You don't know exactly where to go because you don't have ownership information to begin with. I mean, you raise concerns, for example, about criminal threats to these companies, but in fact, the law is very clear under Title 31. Penalties only accrue fraudulently reporting this information, willfully and fraudulently reporting information, that is false. And somehow or another, you've cast this as some kind of great criminalization of corporate America. How can that be?
That's a knowing and willing standard, which is usually in the eye of a prosecutor.
Not knowing and willing. It says willfully provide false or fraudulent. That's what the statute says. Not knowing, it says willfully. Let's be very clear about what the statute says.
The gentleman's time has expired.
Thank you.
The gentlewoman